22nd, 2024, the Junta de Andalusia updated the law for RTA home rentals to tourists. The aim of this, of course, is to limit the oversaturation of tourism in certain cities and the inconvenience for others in the community of owners, and therefore keep the tourism sector healthy. However, people who buy a holiday home in Andalusia often base their purchase decision on partial rental income, and the new situation creates uncertainty and confusion in certain cases. It's therefore crucial to check whether your investment is at risk. In this video, I will explain the legal, administrative and practical changes. I do this based on more than 10 years of experience at a Spanish law firm that specializes in purchase guidance for Northern Europeans in Andalusia. Also watch my previous videos, 10 legal tips for safe purchase, which in other aspects is all still up to date. My video with the technical requirements for RTA rental, and my latest video, what and where to buy in Andalusia, with tips for affordable investment alternatives. I'd like to start with the following comments so you can assess whether the change in law is relevant to you. RTA rental from the Registro de Turismo de Andalucía concerns commercial rental of periods shorter than 2 months. Rental websites such as Booking.com and Airbnb can only include properties with a valid RTA registration number. I repeat that the new law applies to urban properties. The rental law for rural property is largely the same in terms of technical requirements, but is currently not affected by the restrictions introduced. The RTA register uses the land registry for 99% of the cases to determine whether the property is urban or rustic, but there are exceptions. The 80,000 existing urban RTA licenses in Andalusia from before the date of 22nd of February 2024 are in principle not at risk as long as they were applied for at the time according to the rules. There was a period where it concerned the declaration of responsibility, so have this checked by a lawyer. And rental profit must really be declared through the IRPF or IRNR income tax declarations. Otherwise, authorities still have the right to withdraw your license. For license applications after the update of the law, the situation depends on the type of restriction. I like to point out that RTA rental is an extensive theme, and the situation now must be individually assessed per dwelling. So indicate your rental wish to your lawyer from the start on, so he can provide you with tailor-made advice within the purchase process. You might try to negotiate a cancellation clause in your reservation contract in which your seller gives you time to investigate this point while the house is taken off the market. In that case, you will not lose your reservation fee if the purchase doesn't go through, but of course this is not a normal condition for the reservation, so this is really just a favor from the seller. By the way, if you want to stay informed about further legal changes in the area of buying a house in Andalusia or RTA rentals, you can subscribe below to this channel. So the first big change in the new law is that all responsibility for the rental activity shifts from the owner to the landlord. This means, for example, that the RTA rental permit must be in the name of the landlord, and he or she is responsible for the entire content of the application as it concerns a responsibility declaration. The landlord is responsible for signing the rental contracts and registering the guests within 24 hours through the online platform with all correct information. This list, unfortunately, recently has been expanded to the frustration of all people involved. The landlord is also responsible for ensuring that the property meets the technical requirements, and random inspections may take place. See my separate video for these quality standards. By the way, the 6-month period of the register to make the name change has already expired by now, but of course it's recommendable to still do so. Towns with a proven oversaturation of tourism can now, within the new RTA law, prohibit or restrict tourism. This can be done in specific zones based on specific requirements, such as having a known entrance from the street, or for example, it could also be done in specific periods. For this reason, you by default now must also indicate whether you rent out throughout the whole year or not. Several towns on the western Costa del Sol and cities such as Seville and Granada are currently looking into whether restrictions can be introduced and whether local legislation needs to be adjusted for this or not. In Malaga and Fuengirola, for example, where most problems are experienced, new measurements are already in force. As I already have indicated in my intro, changes in law in principle doesn't affect licenses from before the 22nd of February 2024. For licenses after this date, there are two options, and these depend on the local legislation on this specific date. If these already contained restrictions, then licenses issued after this date can still be revoked retroactively. However, if the local law still needs to be changed first, then of course the date of the new local law would apply, and therefore there is no retroactive effect. Are you buying a new build property? Well, in that case, keep in mind that at the time of completion at the notary, the local laws might have changed and maybe you won't be able to apply for an RTA license. The rule of restrictions by the community of owners basically already was in force, but the procedure now is clearer, and in the meanwhile the Supreme Court has ruled that a majority of 60% of the votes is required for an RTA ban instead of 100% or unanimity. The limitation needs to be made formal and registered in the Registro de la Propiedad, or the land registry, via the statutes of the community, and therefore will only apply to RTA licenses from after this inscription. If you apply for an RTA license for a home that is part of a community of owners, then you namely must upload the current nota simple of the land registry. As an alternative, the community can also decide to increase the annual costs of RTA homes due to the more intensive use of the communal facilities. Before the date of the new law, you were required to upload the actual LPO, the Licencia de Primera Ocupación or First Occupation License, together with the RTA applications. This now has been changed back to a statement of responsibility, in which you state that you have an LPO or equivalent, which is also permitted nowadays. Ask your lawyer about this because many older properties do not have this license, and in some cases it cannot be applied for either. For example, if there's no individual water contract. If the town checks whether homes with an RTA license actually meet local standards and find out that that is not the case, your RTA license will be withdrawn and you will receive a fine. A note by this theme that it depends on the local legislations if you indeed need an LPO or equivalent for tourist rental or not. Also, the national government is now trying to introduce legislation to better distribute tourism. But in this, they will probably follow the criteria of the local towns, just as the Junta Andalusia now has done. What national legislation can require, for example, is that you must renew your license annually, and therefore inactive licenses will automatically expire. For example, Barcelona already had the 5-year renewal law, but in Andalusia this currently does not exist. Do you wish to buy a holiday home now in Andalusia? The RTA check is part of the extensive legal research at the law firm where I work. So if you send me a price or your budget, I can send you an example quote with all buyer costs and an explanation of the purchase process, plus further information about rental licenses. And if you like, I could also recommend you a good buying real estate agent in the area of Malaga. You can find my email on the website. Don't forget to subscribe for important updates, and of course thumbs up is always appreciated, and I wish you all the best in Andalusia.